Closing arguments are beginning today in a trial involving the Justice Department's antitrust lawsuit against Google. The government and more than a dozen states say Google has turned its search engine into an illegal monopoly, but Google says people like to use the engine and could change it whenever they want. Matthew Perlman has been following the trial. He's a senior competition reporter for Law 360. All right, Matthew, so catch us up on what we've heard so far.
So we had a 10-week trial that ended in November. The allegations in this case are that Google has maintained its monopoly in the search engine market and the market for search advertising by paying to be the default search engine across a range of devices. So it has a revenue share agreement with Apple that makes Google the default search engine on iPhones and iPads. It has a similar agreement with Android device manufacturers that make it the default on those phones. And so the government is saying basically that the Google is using its monopoly power and monopoly money to maintain these monopolies.
All right. So closing arguments. What can we expect to hear for closing arguments?
Google's defense to this case is that the government is looking at the market all wrong. There's competition every time people pick up their phone, not just on a default. So when someone makes a search, there's competition there if they go to Amazon or TikTok. So that's a big point that Google's going to make. Google's also going to say that these companies are choosing us to be the default because we're the best. These companies are making a choice, a business decision of their own, and we're not making them do that. So the government's going to push back on that, though, and say basically, if you are the best, then why do you have to pay billions of dollars to be the default on all these devices?
So what impact will the outcome of this trial have on the way people use Google and the internet going forward?
Yeah, it's not clear. So this trial itself is actually only about liability. So we're trying to find out whether or not Google broke the law. There'll be a second trial after this if we find out that Google is liable to figure out what to do about it. It seems like the obvious solution here would just be to say that Google can't have these default search agreements anymore. So then that'll be a big problem for these other companies, which will have to find other ways to get the revenue they're getting from Google. In Europe, in a similar type of case, they've implemented a choice screen so that people have to choose their default search engine when they open up their phone. But it's not really clear whether or not that's actually been effective in making people choose other search engines and helping to give other companies a leg up against Google, I guess.
I would think that other companies have sort of exclusive agreements similar to Google as well. Does that mean this could possibly put an end to that?
It doesn't seem that there's too many other companies with sort of default search engine agreements. Google has the main ones. But I guess the problem is that you would have the court would be saying, Apple, you can't have a contract with Google. But Apple's not in the lawsuit, so it seems like that would be a difficult thing for the court to say. So it's not exactly clear how exactly this will turn out.
All right, Matthew Perlman, thank you.
Thank you.